Supreme Court made a landmark ruling today telling the federal government it cannot force certain corporations to supply employees with specific types of birth control. Good evening, I'm Brittany Pieper.
And I'm James Packard. Hobby Lobby and Conestoga Wood Specialties are the two companies that successfully rejected the government's mandate. KOMU8's Brendan Cullerton talked to one of the lawyers for the winning team, and he joins us in the studio. Brendan?
It's one of the biggest challenges ever to the Affordable Care Act and the most successful since the Supreme Court ruled the government couldn't mandate states expand their Medicaid programs. Josh Hawley, one of the 15 lawyers representing Hobby Lobby and an MU professor, told me the biggest takeaway from this case is giving more Americans more religious freedom.
Hobby Lobby wins! Hobby Lobby wins!
The U.S. Supreme Court ruled 5-4 today that for-profit companies owned by 5 or fewer people or a family can use religious objections to refuse providing employees with types of birth control that terminate already fertilized eggs.
The Supreme Court said today that the administration cannot force business owners or any American to give up their religious faith in order to do business in America.
The decision applies to the arts and crafts chain Hobby Lobby and the wood cabinet company Conestoga Wood Specialties. Both are family-owned, and the owners say requiring them to provide contraceptives would infringe on their religious liberty. A majority of the Supreme Court agreed.
We have a long tradition in this country of protecting religious liberty and religious beliefs of all kinds. You know, one of the best things about the United States is you're free to practice your religion, whatever it is, so long as you do it peaceably.
But opponents of the decision say the ruling discriminates against women and endangers their health by denying them birth control.
This court decision favoring the corporation over the person, over the actual living people, is both part of the war on women that we've been seeing for decades.
The majority opinion stated the government must have a compelling interest to curtail a company's religious freedom, but also that it must do so in the least restrictive way possible. Justice Samuel Alito wrote the government could find other ways to ensure women's access to contraceptives without requiring companies to pay for them. Opponents say this ruling is a slippery slope and opens up all kinds of ways for companies to discriminate against religious and ethnic groups based on religious principles. Believe it or not, not-for-profit religious organizations are not exempt from providing the contraceptives like the for-profit ones. Hawley told me it's just because the Supreme Court happened to hear this case before any involving non-for-profits. He expects them to be afforded the same religious protection soon.